kind of shocking for a lot of people, I think.
Right. What we had today was a preliminary hearing in Roane County General Sessions Court in front of Judge Terry Stevens with both the defendants that were arrested yesterday, Michael Anthony Gray Sr. and his wife Shirley Gray. They're at 1275 Dry Fork Valley Road here in South the River, Roane County. The charges that were outlined yesterday, the especially aggravated kidnapping charges relative to two of the children, the aggravated child abuse to the same two children, aggravated child neglect to those two and a third child, and then the abuse of a corpse to a dead daughter of this family that was found, it was discovered in the backyard in a barn actually in the early hours of Saturday morning. And so obviously that begs the question about additional charges relative to how that child died and who's responsible and how for that child's death. As I stated in the press conference yesterday, we're waiting on some further analysis and testing of the skeletal remains of what we believe to be a daughter, minor child daughter of the family. The information was gathered in an initial investigation, an interview with the father, Michael Anthony Gray Sr. As I conceded to the court in the bond hearing, they had been cooperative with law enforcement up to the point of arrest, but they have no ties to the community other than the 4 years they've lived here, no family, and with their children being in custody and have been in custody with the Department of Children's Services since the bodies were discovered there early Saturday morning. Actually, they went into custody initially Friday evening. There's no real reason for them to stick around with charges of this nature hanging over their head as outlined in the press release. If convicted, especially of the A and B felonies, they require mandatory day-for-day service on significant prison terms. And then also with the potential pending murder charges, obviously waiting on the testing results to confirm what we need to bring about those charges.
Sir, am I understanding correctly that the 15-year-old boy was kept in the basement for 4 years almost?
Okay, here again, if I would say that's correct from the narrative that you heard the judge read in court and from the public document. As the prosecutor in the case, I'm prohibited by ethical rules from going into the facts. I can tell you the timeline of what will happen next. They were appointed counsel. Robert Kurtz was appointed to Mr. Gray. The Public Defender's Office, Kim Nelson, was appointed to Mrs. Gray. They will have an initial appearance on June 9th if they're unable to make bond. If they do make bond, then that's pushed out a little further to June 23rd. So, but if you can take your facts about the case and the details about the case instead of my mouth, so I don't get in trouble, take that with from what you heard from the judge's mouth today and the video that you got there, and from the warrant itself. That's pretty extensive and pretty detailed, and like I say, is kind of hard to absorb.
It is.
You would think with the charges that were dropped on these people that they would probably be a little less cooperative. Did your office feel like they were pretty cooperative for the significance of this case?
As I conceded to the judge for his analysis for determining bond, they were cooperative up until they were taken into custody. No one's attempted to interview them since they've been in custody. But as you can read in the narrative, each time they were interviewed, they affirmatively and in writing, the narratives indicate that they waived their right to counsel and agreed to speak and cooperate.
Where did the kidnapping charges come from?
The kidnapping charges are relative to one element of kidnapping is false imprisonment, and then the especially aggravated factor is due to the age of the person. So an element we would have to prove for a kidnapping charge in this case is the young age of the child and the fact they were essentially false imprisoned. I know the general public thinks of kidnapping that you go and take someone. In this case, we hear about Amber Alerts and kidnapping situations. It's not that type of kidnapping. It's false imprisonment of a child under 13 years of age.
Sir, can you speak at all? I know the neglect charges came, I can imagine from where the narrative the neglect charges came, but can you kind of walk us through that and the state of the children when investigators came to the scene?
Like I say, there again, I'd rather not talk about the facts. You know, prosecutors are limited from talking about the facts, so if you can read through some of the things you heard in the narrative and maybe kind of feed that into what you're doing as far as the treatment they received. I think for what the judge read from the bench, that's pretty well documented, and folks will have a good understanding when they hear that.
A lot of people are going to be really angry when they read that and hear that. They're going to want justice immediately. Can you talk about why it might take some time?
Okay. We're at the preliminary hearing stage, would be our first hearing that we have. We have grand jury in Roane County in 3 weeks. So if we were to get a preliminary hearing on June 9th and get it bound over after a preliminary hearing or waived by the defendants and their attorneys, then we can get it to grand jury, which gets us to an indictment phase and ostensibly gets us into criminal court before Judge Jeff Wicks, and it gets moving along. If we don't make that date for grand jury, then because of the way we have 4 counties and our grand jury is a circuit process, we're not back in Roane County for grand jury until October. So it's very likely that we will have a grand jury meeting on this case in October. It will be ambitious to expect we can get it there in 3 weeks, especially when you have a potential murder charge added to the case. Then that brings another dimension of delay as far as attorneys anticipating post-conviction and appeal. When you're talking about upping the ante as far as life imprisonment or life without parole or even death penalty considerations, which we have not engaged in at this point. We aren't even ready to talk about that because we don't even have a charge yet. We don't have a charge yet because we don't know the results of the testing and analysis of the testing on the skeleton that was found in the backyard in the barn. So we're getting the cart before the horse and a little premature to even talk about that. So we'd rather focus on the charges that we have here today that we're looking at trying to sustain at a preliminary hearing.
It's not easy for investigators or prosecutors to have a case like this, not because it's complex, but because it's very personal. Kids, vulnerable, innocent people being treated in the way that is laid out and documented here. Can you talk about the impact on prosecutors?
Sure. You know, everything you talk about, especially the investigators, keep in mind, as I spoke about yesterday, Art Wolf, John Mays of the Roane County Sheriff's Department, Courtney Duggar of the Child Crimes Unit with our district, all 3 of them were on this case basically around 9 o'clock on Friday. I know they didn't get any sleep Friday night or Saturday. They were out involved with finding the remains, continuing to interrogate or question folks in this case, interview folks, and that took place all through the morning Saturday, all through the day Saturday. The individuals were interviewed more than once, and then Sunday was spent over at the Child Advocacy Center for these people and my attorneys in the background, where Carrie Watkins at the Child Advocacy Center was conducting forensic interviews of the 3 children that are still alive. That started somewhere around 9. The interview started a little bit later, but 3 children to interview. I know they didn't get finished till around 5 or 6 o'clock. And then I know I was on the phone and meeting with folks late through that afternoon, and still Monday. We finally decided that it's time. We're at this stage where we need to go ahead and charge, even though there's much investigation to be done. We talked about waiting till all the forensics testing was completed with Dr. Marks. We don't know how long that's going to take. We're hopeful he was able to get started today. Talked about Dr. Darinka Malusnik-Polchin coming in on a Sunday to look at the skeletal remains and do what she could do with it, but that had to be passed on to the anthropology department, which will take place today and later. If you'll remember, we had a case involving a child named Clifford Dotson who was starved to death by his parents. That went on for years. Anytime you have a case of that nature, talking specifically about that one and might be able to relate it to a case like this, there were a number of experts that were involved, a lot of expert testing, DNA testing of the skeletal remains that had to be sent off, took a lot of time. So they get an expert report. We in turn get a expert report to either confirm or to deny some of the analysis there. So that went on for years, but we were ultimately successful because we took the time to get it right.
It's a long process.
Right.
You described how the long hours everybody worked over the weekend. It's
Right.
emotional too. Can you talk about that aspect
Absolutely,
of it?
especially people doing this that have children themselves. So not only the physical drain, but the mental drain. Allison Kennedy in our office works with our child sex unit, so she sees it day in and day out. And you know, you worry about someone having to deal with so much of that, but it really takes a toll on anybody working on the case. So.
Why equal charges? It looks like both were charged with the exact same stuff.
And say you usually do equal charges when there's equal responsibility. As you can imagine, this is husband and wife that are the parenting figures for these people that are legally in charge of them, and all this is going on in the same household. So that's why.
Okay. And do you think down the road there will be some sort of mental health evaluation of the parents?
Speaking to any case of this nature where the charges are this serious and given the elements of the offense necessary, defense attorneys are going to do their professional duty, their due diligence, and their CYA for post-conviction relief to say that they've done their job, that they've gotten all the mental evaluations to determine not only sanity but competency to stand trial. So those will come fairly early. They will take time, and then depending on the outcome of those results, we may also get state experts to review those results and do independent testing.
Now earlier, I think it was you who said it, but there's no, you can't allow pleas in this.
The judge, when he was talking to Raymond today, because the charges are felony charges, you can't plead to a felony in General Sessions Court. General Sessions Court is of a non-trial level, lower jurisdiction. You can only plead to a misdemeanor charge. In General Sessions Court, you can reduce felonies to misdemeanors and do pleas, but that obviously isn't going to happen in this case. And just because of the serious nature of the charge, he wanted these people, I feel, to be able to talk to an attorney first before they consider any type of disposition. And there will be a lot of due diligence and a lot of work that the defense attorneys will do before they even talk about whether they want to negotiate or not. So that's well down the road.
Okay.
Anything else that we're missing, sir, that you support to talk about at this stage?
I think not. You know, we're in for the long haul on this. This is just the beginning. Like I say, a lot of the investigation is not yet concluded. You know, depending on the timing of the case and what may or may not happen at grand jury, if we get in that spot in 3 weeks, there'll be more news there. And I can tell you, just hold on tight. There's a lot more to come.
Thank you, sir. I
Thanks.
appreciate your time.
Thank you.